On the March 6th ballot is the race for district attorney in Brazos County. The current district attorney, Jarvis Parsons, joins us today. Thanks for being here.
Thank you for having me.
Let's start first. Give us some background on your education.
Okay, so graduated from McNeese State University, born and raised in Southwest Louisiana. Graduated in speech communication and was on the debate team, and then went to law school at the University of Maine. While I'm at the University of Maine, I interned at the district attorney's office there in Cumberland County, and they said that a prosecution was the one job where your one goal is to do the right thing, and if you can say that you've done what you're supposed to do for that particular day. And I fell in love with it. Graduated from University of Maine, got a job as a law clerk in New Jersey, and wrote opinions for a judge. And while I was in New Jersey, there was a prosecutor there in New Jersey I worked with who knew a prosecutor in Brazos County and got a cold call. God opened up this door, had a cold call. There's a long story in between, but the job had opened up about 48 hours prior to me calling the second time. And my wife was a speech and debate coach, and there was a job that opened up at A&M Consolidated about a week prior. And so she interviewed first. They offered her a job. She said, it depends if my husband gets the job. And the principal said, well, I know Bill Turner. I'm just going to call him and tell him to offer your husband a job. And we came sight unseen for the job. We got involved in our church, and that was one of our foundational pillars. And then we got involved in our work, and that was the work at the DA's office. And so that's how we got here, and it's been a great experience.
Let's talk about the office under your leadership. Current DA's office has experienced significant turnover in the past year. What steps can the DA take to stabilize that personnel situation?
Well, I think the first thing is a reframing of the question. One is that turnover has happened across the board, across the nation. So if you ever Google prosecutors and turnover, that has happened in a number of places. A number of people left the profession. In our situation, we had a couple of things happen. A couple of our prosecutors were asked to become first assistants in other areas, which was a promotion. Another prosecutor, or two prosecutors, were asked to go to start the public defender's office, and one, Nathan Wood, was the chief public defender. My opponent then left the office to go become a defense attorney at the public defender's office in January of 2023. So some people left for those reasons right there. I don't really count it as a loss in terms of turnover when a person then goes and gets a higher position, kind of like a coaching tree, like Nick Saban on a coaching tree. So if somebody's looking at our office and saying, we want to use this person as our first assistant, I already have a first assistant, that person has a floor there. But if you look at our office and our supervisory staff, at every single level, we average 20 years of experience. So every single one of my supervisors know how to prosecute all different types of cases. And our disposition rates in terms of moving cases has not slowed down. So from January 1 of 2013 to December of 2023, our disposition rate, which means the speed at which we move cases, is 114.9%. So give you some context. That is 7th in the state of Texas. So the top 3%, which means our offers are effective. We get higher offers and get higher verdicts in other places around the state, and we move cases faster. Are there outliers at times? Yes, but on the whole, we are one of the most effective counties in the state of Texas, and the people that are above us, the most populous county is only 12,000. So at 240,000, we are heads and tails above any other county in the state of Texas.
What's your philosophy or attitude toward how much discretion you give a line prosecutor?
A line prosecutor. So there is a prosecutor manual, right, a guidelines, where I go over the philosophy of the office with them one-on-one to know exactly what kind of cases we have and what kind of cases are worth. How do we deal with nonviolent cases versus violent cases? How do we deal with threats to loss of life? How do we deal with domestic violence? How do we deal with sexual assaults of children? Which is important to have that kind of philosophy and have that experience, because that's one of the decision points or the areas where I have experience and my opponent does not, is in those tougher cases. So I understand and can impart that understanding to my assistants and how we are going to try these cases and what kind of offers to have on those cases.
What do you believe is the role of the elected district attorney? A manager, a leader, a trial lawyer?
So that depends on the type of staff. I think one is that the district attorney has to be a leader, and you have to be a leader, somebody a leader is somebody that people follow. One, it's somebody that charts the course Two, and has the respect of the people in their office. So if you're looking at me as in particular, I believe there are three things that show what a district attorney should be. And one is leadership. I have led the office for 12 years. I've been in the office for 21 years. And not only have I been a person that's been in the trial courts, but also leading in a couple of different areas. One, we've learned by data-driven prosecution that domestic violence creates more than half of our violent crime. So we started throwing our time and energy at that, analyzing it and specializing in training prosecutors in that particular area. We not only train prosecutors, but EMTs, nurses, doctors, police officers, to make sure that they understood the signs and symptoms. I know it doesn't look like it, but I know a lot of hairstylists. And so we trained hairstylists to recognize the signs and symptoms of domestic violence. And what has happened is from 2014 to 2021, we have increased domestic violence prosecution by over 500%. So that is one of the things that we've done in terms of leadership. Two, that leadership has been recognized because I've been appointed by Governor Abbott to the Forensic Science Commission, which oversees all of the forensic science in the state of Texas. So when we're making sure that the science that is used in trials, not only here in Brazos County, but we're a model for the state and for the country to make sure that it's fair so that innocent people are not going to jail and guilty people are going to jail. The second thing is experience. And so I have 21 years of experience, and that is important when it comes to leading an office because you have to be able to take people where you've already been. So the type of cases that I deal with on a regular basis, and when I go and try cases, is a little bit different than when other people try cases. So I'm trying cases where there is a murder, or we're going to seek the ultimate penalty, which is a death penalty, which also my experience is unmatched in this particular area because my opponent does not have any of that experience. And so I've done 4 of those. So I know what it takes to get that verdict. I know what it takes to create courtroom quality evidence in this particular area to make sure that when we have a verdict, it stays, it's not going to get reversed later on or any of those different things, that it sits there and that person stays on death row until they get the ultimate punishment. And lastly, the role of a district attorney is training, which means I can't be everywhere in the courtroom. There are 3 different courts and really 4 different courts with juvenile. So my job is to impart my knowledge and skill into my assistants so that they can go and do those jobs as well, because we could not. The office would shut down if I'm in trial all the time, and I wouldn't be able to do any of the other things that we're able to do here and be as effective as we are statewide. So I've been blessed enough and lucky enough to be recognized as Prosecutor of the Year and receive the Chris Marshall Award for training. That's a statewide award. I get to speak to over 500 baby prosecutors or new prosecutors each year to train them, and so my supervisors all train. So that training model is built into the system. And the last thing that we do is that while I'm not in the courtroom every single time, we do something that I instituted called boarding, which means every single jury trial that goes to trial comes through me. So they set it up on a board, we go through, and my job is to try to poke holes in that case. And if they can run it through me, then we know that the case is going to be set up for success. It doesn't mean that we hit all the time, but 9 times out of 10, the defendant is going to be held accountable for his actions. And I attribute that to the idea of that multiple people in the room can give wisdom on a case, and if they can get through me, an experienced 21-year trial lawyer, then going through a jury is going to be a lot easier.
Let's talk about death penalty.
Yes, sir.
Obviously, they are extremely difficult. They are time-consuming.
Yes, sir.
They are expensive.
Yes.
What is your criteria for deciding when to seek the death penalty?
So when I seek the death penalty, I have been a second chair on 1 and a first chair on 3. First of all, there is no doubt of the defendant's guilt. We are not going to be in a situation of this is probably or anything like that. If there's no doubt of the defendant's guilt, that is the first step. But the second step is super important, is that of whether or not this defendant is going to commit criminal acts of violence in the future. If we believe that, then we move on to step 3, which is we're going to look at everything and we're going to chop it up and make sure that we bring a lot of heads in here to figure out if there's anything that would contribute to be a sufficient mitigating circumstance to warrant life rather than death. These are the statutory figures, but they are so important because this is what a jury is going to do. They're going to do this every single time. And so the main thing is, are you going to be a danger to other people in prison? And there are individuals, and I will tell you, we've had some cases where we tried them, and we have been worried. When we seek death, we firmly believe this individual will be a threat to people either in the prison or outside of the prison. Gabriel Hall is one result. I don't know if you remember that case. It was from 2015. It was a person who, for 2 years, sought to kill someone, picked out an elderly couple in Edwin and Linda Shar, watched them and stalked them for 6 months, and killed them for no other reason than to see them bleed, and almost killed Linda Shar by missing her carotid artery by 1 millimeter. And so I took that case on. We went to the Philippines. We worked on that case for 2 to 3 months beforehand. We tried that case. It took us 3 months to try that case, from July to October, July, August, September, October. But we got the correct verdict in that particular case, and it takes a ton of skill, a ton of work, a ton of timing to do that. Now, we've had other cases that are close to that, meaning that cases that are that we've started and we've tried to go. There's one case, I won't say the name of it because the victim in the case does not ever want to hear the name, and I don't know if she's going to be listening. But he left prison on a Friday, and he killed Mac and Noel Devon on a Sunday and burned the house up. And so we were getting ready. We had 10,000 pages of medical evidence. We're getting ready to go. We had said that we were going to seek death. And while we are getting ready, preparing to go to trial, he ends up committing suicide in the jail. We had a couple of other ones, Rufus Lockett and Danny Diaz, who were going to be death penalties. But then when we realized that with Danny Diaz, there was a hitch in the law that he was in the middle of. He was not technically eligible for the death penalty. We decided we're not going to spend $1.5 million or $2 million total to try to seek something that we didn't think that we could get. And so he pled to 2 life sentences stacked on top of each other. And Rufus Lockett, which killed a woman, Anita Randall, at the Valero convenience store by the Scott and White, we had that case and we were set to go on the death penalty on that one. Unfortunately, the judge threw out the confessions of the defendants at that time, and that changed the case. And so we had to then change course, and we ended up pleading that case to life without parole. So all of those individuals are the cases that I deal with on a regular basis.
On the other side of the spectrum, there are those who would say that this office has not been aggressive in cases involving white-collar crimes, small businesses.
Okay.
Your thoughts?
I would say that if somebody has a specific case, they can always come and bring it to me. We get our cases from law enforcement. And so law enforcement brings us the case and lets us know what their recommendations are on a particular case. We don't have a ton of white-collar cases that come through. They are complicated, as you know. They're complicated cases, but we have individuals who are equipped to handle those cases. And when we have brought those cases to certain judges, i.e. in the 272nd years ago when we started and we had a white-collar specific person, when we would ask for prison time, unfortunately, the judge may give probation on that particular case, kind of a yin and a yang, trying to get the victim their money back and try to send a message to the defendant. Many times we think that the sentences need to be a little bit harsher to try to deter that type of crime. But any case that comes to us, it comes from law enforcement. So if there's ever a question about that, my phone number is 979-218-4969. You can call me on my cell anytime, and we can walk through those cases and try to give an understanding as to why or why not a case went through the court system or got indicted or didn't get indicted.
Prosecutors are sworn to do justice, not to seek convictions. What does that mean to you?
It means that we have to do the right thing at the right time for the right reason, regardless of what it looks like to the outside. And so prosecutors, and I've heard this before if you go to prosecutor conferences, is that you're constantly working yourself out of a job. And what do I mean by that? It means that, unfortunately, if you're doing your job right, it doesn't matter who's the defendant. It doesn't matter how much money they have. It doesn't matter what their family name is. It doesn't matter how they're connected. It means that we, as prosecutors, look at the facts and make a call based on those facts. And that has cost me in certain situations because some people have said, you know, if you prosecute this individual, then that's going to be bad. This person is will switch their support. This person is a big donor. And I say that if we're doing our job as a prosecutor, none of that matters. And so the good thing about me is that I don't have those sort of ties. I have my church, and I know God's got me and my family, regardless of what happens. And I have this job right here, and I was taught well to do this work no matter who the defendant is, no matter who the victim is. And I'm going to make a call that is straight on the facts and not going to waver from that.
Do combat veterans returning to civilian life who get caught up in the criminal justice system deserve some sort of special consideration in light of their service?
I think kind of what you're getting at right there is more of, we've had this conversation about Veterans Court and whether you have a mitigation. So the short answer is yes, that is true. And so let's talk about Veterans Court in general. Let's kind of take the elephant in the room. I support a Veterans Court, and so we got to talk about what that means. A Veterans Court, by statute, says that you are not charged with anything, and it's almost like a pretrial intervention program. So I support a Veterans Court in the world where you're talking about low-level drug use, so you have an addiction or something like that, that's from your PTSD, credit card abuse, a theft, something like that where it is nonviolent. And I have an example of that because we have a diversion program for people with little to no history or have mitigating circumstances where we have put people in this program to be able to say, you can get your case dismissed. And so I believe the same thing for a Veterans Court in terms of those type of nonviolent cases. Here's the concern, and there's a reason behind this. When we talk about violent cases, that is what I deal with, meaning if you break your girlfriend's arm, leg, jaw, if you physically injure children, if you sexually abuse a child, any of those type of things, right there, if you're pulling a gun and shooting someone, all of those things at some point in time, depending on the courtroom quality evidence, could be worthy of probation. The statute as it is written right now says that you get an expunction for anything that's in the Veterans Court, meaning the low-level crime and the violent crime would go away and there would never be a record of it if that person happens to reoffend again. And that's problematic for two reasons. One, the prosecutor needs to know that if a defendant happens to reoffend again, to let a judge and a jury know this. If it's expunged, it goes out of everyone's database, police, prosecutors, everyone. Two, the police need to know when they stop a vehicle that what this person has done, what their issues may be, do they have violent tendencies, and they don't have a clue on those cases. What I've learned is that there's a ton of different ways to do veterans courts. Tiffany Love is the coordinator for our region. She says that everyone does it differently. McLennan County and Montgomery County have really good models. They have more veterans than we have in our area that commit crime, and frankly, we don't have that many veterans that are committing felony conduct like I'm talking about. But we are looking at this right now to try to figure out a way to expand it. And so what I have said is we can go through a veterans court. You can go in and if you complete it, you can get a dismissal of your charge, which is great. More so, you can get what's called a non-disclosure, which means employers can't ask questions because you can say, hey, I am not a convicted felon. My case has been dismissed by a district court judge, and you can't ask me questions about that. So there's an order of non-disclosure. And so in that way, they still get a second chance at life, and we still have a record just in case something happens. So let me tell you why this is important to me. My second death penalty case was a guy by the name of John Thiessen. And John Thiessen was a Marine who had a stalking relationship with a girlfriend in high school, a little small one, came back from the military service, had a girlfriend in the Belleville area, stalked her, controlled her, choked her, beat her to the point she went into hiding. And so what happened was her parents at the time decided, hey, this person, let him get a second chance at life. We're not going to prosecute because he's a military veteran. She went into hiding, and then he met Rachel Joyner, who had no idea what happened. And so when Rachel broke up with him, he stalked her, he broke into her home, he shot her, and then when her brother came to intervene, Travis, he shot him too. Once in the heart, once in the spine, paralyzing him, and once in the liver. And then as she tried to escape, he shot her again. She should have a right to know, and her parents should have a right to know about his prior history if he reoffends. His employer doesn't need to know if he doesn't reoffend, but police need to know, and the prosecutor needs to know. And we can't take that chance on serious felony conduct. So I'm all for a veterans court. We just have to figure out the details. And frankly, I want it to be more expansive because the way the statute is worded right now, it says that the PTSD trauma has to be related to the conduct. My thought is, even if it's not related to the conduct, we could still put this person in the veterans court and deal with this issue and this issue. But under this model, it's not. And so I'm working with the judges right now to try to see if we can get a veterans court that we can all live with and get a judge that'll take it on because they're busy. So we could help all the veterans and keep the public safe.
What role does rehabilitation play in prosecution?
I think it depends on the crime. So sexual assaults of children, physical abuse of children, things like that, rehabilitation is very, very, very low on the totem pole. When we're talking about drug offenses, right, a user amount of drug offenses, that becomes very high because we want to deal with the issue, and we work with places like adult probation and juvenile probation to try to get people back on the right track to make sure that they are contributing members of society and they can get back into the economy because we know that there's a labor shortage. One of the things that we've done to increase that is to do what's called a pretrial diversion program, where if you have a low level of drugs or a low level felony, and you have little to no criminal history, so you just stubbed your toe, we will allow you into the pretrial diversion program where you will drug test, you will call in, go report to probation, and it's random drug testing. And if you do that 12-month program, you can get your case dismissed, you can get it expunged everywhere except our office. So just so that we have purposes and that we know what's going on so you don't go through it multiple times. We've seen in other counties where they expunge it and people come through 2, 3, 4 times. It's been wildly successful. It's about 75 to 80% successful, and people have got a chance to get a second chance at life when they straighten up and flew right. And so that's kind of what we talk about. We talk about rehabilitating and getting people on their way. That's what we want to do because we want to be their biggest champion when that happens.
So sometimes legislatures will pass legislation that's controversial. Are there any laws that you would feel uncomfortable prosecuting? Example is a recent case involving a woman seeking an abortion in Texas because her fetus was not viable, and carrying the pregnancy to term would threaten her life and her possible ability in the future to have other children. The Attorney General threatened to prosecute any hospital or physician who performed an abortion in that case. So the short question,
yes,
are there some laws out there that you would not prosecute?
The short answer is no. So, and let me tell you why. Because one of the things that we have as a check on government power is the grand jury. And the grand jury comes in and looks at a particular case and decides whether or not this case has enough evidence to proceed to trial, or if they want to even have this case in the trial courts at all. And so what we do is that we take cases that we have and we bring them to the grand jury if we believe the evidence meets the statute of the crime, and then we let the grand jury decide what they want to do. If the grand jury says, yes, this is a prosecutable case and we're going to go forward because we're going to give them everything, then we move forward. If they say, no, this is not something we want our tax dollars being spent on, then we listen to our community and we go forward in that way, because you have to have a true bill from a grand jury to do that. And that's important because it is not just the prosecutor making that call. It is the will of the people who are there, who are duly selected, to say no, regardless of what somebody else may say. We say no or yes. I think my job as a prosecutor is not to legislate. That is not what we do. I don't think that's a conservative philosophy. I don't think that's what we need to be doing. Our job is to hold people accountable for the crimes that are on the books that the legislators put on the books. But the grand jury is the ultimate check on that, because they can decide what kind of cases go into the courts and whether or not that is justice.
Do you believe the war on drugs has been effective? How would you handle low-level drug offenses?
I think it is a mixed bag at times. I think that law enforcement does a very good job on those cases. And I think there are some prosecutors who at their peril say, well, we're just not going to prosecute this, because I still feel that some of the low-level drugs lead to other types of crime, i.e. criminal trespass, thefts, things like that are crimes of addiction. So I think that we still need to go after these type of deals. How we deal with those individuals is different than how we used to deal with them. We want to deal with them in a way that is humane, that is empathetic, that is rehabilitative in terms of getting them on probation, getting their lives turned around, getting them on a substance abuse caseload, and figuring out are there underlying issues. One of the people that we love working with is on the MHMR caseload and on the specialty court caseload. And so Jessica Eskew is one of our prosecutors who handles the drug court caseload, and someone like Angela Sullivan handles the MHMR caseload at probation. And so we work with them and work with MHMR to say, is there an underlying issue? Can we get all of those things wrapped up so we can treat the whole person so they don't come back and waste our time, our tax dollars, and not treat the underlying symptoms? Or are we going to do the whole person, make it holistic, and hopefully that person be able to go back into society and not come back and reoffend?
There are 100,000 students basically in Brazos County. What's your approach when it comes to addressing offenses that are committed by students?
I think it depends on the offense. So they say Aggies don't lie, cheat, or steal. So I'm going to go with that. Totally fine. I think it depends on the offense. So, for example, if it is a low-level offense, we will treat college students the same way we treat citizens who are here in this county. So the fact that you are here from Dallas or Houston does not mean that you get more punishment, but it also doesn't mean you get less punishment. We're going to take into account the factors that you have that are unique, but not based on your status as a college student. It is based on the fact of what you did, and everybody is equal under the eyes of the law. And I think that's just kind of one of those things that I go back to. It's not about the politics or anything like that. It's just about the hard work to make sure that individuals who commit a crime are held accountable. And then if we have courtroom quality evidence, we move forward. And if we don't have courtroom quality evidence, then we don't move forward on those particular cases, regardless of who you are, where you live, or where you come from.
Texas Attorney General is waging a battle to have independent prosecutorial authority to prosecute election fraud cases. Recently, the Criminal Court of Appeals handed down a decision ruling against the Attorney General having original prosecutorial jurisdiction. In your view, where do you stand allowing the Attorney General to have the original prosecution authority in an election fraud case?
I believe that the local district attorneys and the AG's office work best when we're working together. And that is with the consent of the local elected district attorney, which means a person that's accountable to the citizens, making the call, and then deciding, is this a little bit too complicated for us right here? Do we need to bring somebody in to step in? Because that is how it's worked for the last umpteen years in Texas. And so this would be a sea change, and I don't think that's good. We have called in the Attorney General's office on a number of cases, and it's worked out well in those situations. And so I don't think that we should change that right now. The original jurisdiction for the case is where the crime was committed, and that is under my jurisdiction or Earl Gray's jurisdiction. And I think that is the best way to handle that locally, as opposed to giving that authority to someone that doesn't live here and that is not accountable to Brazos County citizens.
Anything we haven't covered today?
I don't think so. I think that I want to just to kind of hammer in a couple of things. I think that experience in this race is going to be key. I think my 21 years of felony prosecution experience is unmatched in this race. I think that my experience with trying murder cases, child sexual abuse cases, capital murder and death penalty cases is also unmatched, and I don't think there's room for on-the-job training. I think that we being able to train prosecutors and be able to get them ready to go requires a level of experience that is unmatched in this race, and I believe that I have that level of experience and respect in that area from the prosecutor perspective. And I think that that's what this race comes down to, and that's in my opinion what it's about. And so I think that what you want in a prosecutor is someone who's able to make the right call, use independent judgment, and have a moral compass that is centered on what is best for the community, what is the law, and what do the facts say.
You have a website, people?
I do. It is parsonsforda.com. And what we've done is that we have put up for the last 13 years, we've done things like press releases. And so you can see at parsonsforda.com, if you click the link that says Tough on Crime, We'll have cases broken down by crimes against children, crimes against women, robberies, violent crime, property crimes, and DWIs. And you can go in and see exactly what we've done. It is not enough for a person to come in and just say, oh, I'm going to be tough on crime, or I'm going to do this, or I'm going to do that. I think it's super important to make sure that people know this is exactly what we do and that we have the skills to be able to get these things done and get them done regularly in the courtroom.
Thanks for the time.
Thank you very much. Appreciate it.